Great. Okay, so good afternoon, everybody. Welcome live from my living room. I'm Larry Pearson, one of the partners at Wigdor LLP, and I hope that you and your family and friends are staying safe and healthy and are comfortable even during this terrible crisis that our country is going through. I'm here today with two of my colleagues at the firm, and I'll let them introduce themselves.
Hi, my name is Hillary Orzik. I'm an associate here at Wigdor LLP. I've been with the firm for about 3.5 years, and I'm here to help answer your questions along with Larry and Julia.
Hi, my name is Julia Almalay-Sachs. I'm an associate here at the firm, and I've been with Wigdor LLP for about 1.5 years. And I'm excited to be here this Friday again with Larry and Hillary to answer your questions related to these difficult times that we live in.
Yeah, thank you. Just a little bit about our firm before we get started. We are an employment litigation boutique located in Union Square. We also have operations in Florida, and we represent almost exclusively individuals, people, employees who work in every industry and for every type of company, everything from the largest financial houses and Fortune 500 companies down to people who make an hourly living, work for minimum wage at small local businesses, and represent, by that token, all sorts of people, everyone from professional athletes down to people who serve you your food when you go out for lunch during the workday. So if there's something in employment, we basically handle it with a focus on litigation oriented matters: discrimination, sexual harassment, retaliation, breaches of contract, and a host of other potential legal claims. Thank you for joining us for this third installment of our weekly Q&A series. We have a few timely topics prepared in advance that each of us will address, but also if you have questions, please give them to us as we go through things. And it could be about the subject or about anything else you want to talk about. And you can do that either through the live stream, or you can email contact@wigdorlaw.com. That's CONTACT @wigdorlaw.com. And our moderator will keep us apprised of all of those. We can't provide legal advice on this live stream, but that said, we can definitely have a more detailed conversation offline, and also give you a general idea of what the law is and what common practices in situations that you bring up. So feel free to bring up any questions that you have, and just give a little bit about the different topics we have this week, and then we'll get started. So I'll be talking briefly about the sorts of documents that a person typically gets in their severance packet if someone is laid off or terminated in connection with the reduction in force, that sort of thing, and the types of questions or issues that often come up in connection with severance, Cobra, that sort of thing. And there are some, obviously, topics branch off, but we'll get as much in as we can in the hour. And then Hillary and Julia will be covering a couple of other topics that they are definitely well-established experts on, and I'll let them talk a bit about that. So Julia, Hillary, would you like to give a bit of a preview?
Sure. So I plan on talking about unemployment insurance availability and eligibility. Specifically, one issue that's come up a lot and that we've received a lot of questions on is whether or not someone can quit their job and still be eligible for unemployment benefits. And the lawyerly answer to that is it depends. So I'm going to spend a few minutes just talking about what it depends on and when someone can quit their job and still be eligible for unemployment benefits.
Great, and I'll be talking today a little bit about the New York whistleblower law and what types of complaints employees can make about their employers, and the types of issues, public health and safety issues that they might be facing in the workplace. And then I'll also be showing you guys where you can go on the New York State Department of Labor's website to make a complaint.
Great. So we will Yeah, like everyone just said, we will be showing you some of the online resources just to give people an idea of where they can find government information. And obviously, any questions you have about any of those topics doesn't need to be in order. Just send them to us whenever you would like. Okay, so getting started on severance packages. There may be some people listening who work in HR, work in the legal industry, and you may already be familiar with some of these documents, but there are always wrinkles and things that come up in these situations. But let's just start with which documents a person generally gets when they are part of a layoff, unfortunately. So they'll generally get a severance agreement if the employer is offering severance. And that severance agreement will generally include a few basic provisions. It will include a general release, which is the most important part of one of those severance agreements. A general release is a very, very serious legal provision. It basically wipes the slate clean for you as an individual with that employer, and generally all of that employer's affiliates, all of their officers and management, their employees. So essentially, once you sign that document, you may have a revocation period in certain circumstances, but once that document is signed and in effect, you have essentially waived your right to bring legal claims against those people and those entities. So something definitely to consider very seriously before you do it, and to be aware of that it covers everything, even claims that you may not even be aware that you may have had. So when you have a severance agreement, a very good idea, of course, to read it yourself in the first place, but also to have somebody take a look at it. That severance agreement will also generally contain a confidentiality provision, meaning that you cannot talk about how much in severance you received or the provisions of that severance agreement. And sometimes it will even say that you can't talk about the circumstances of your employment, and contain a provision that is called a non-disparagement provision, meaning you can't make negative statements about your former employer or the managers or other employees there. Again, that long list of different people and parties that are part of the agreement or benefit from it. Other common provisions in those agreements would be that you need to return all company property. Companies aren't always very careful about making sure that they request all their property back, but it's generally not a good idea to try to get away with keeping company property, especially if you haven't had a chance to get your own property back from the company. You can certainly make sure that you have that company property ready if and when they ask for it, or if you choose, you can volunteer it and make it a part of the conversation, saying, and by the way, when am I going to get my picture from the wall, or kids' pictures from the desk, or whatever the most important items are, if you did not have a chance, weren't given the chance to gather your belongings before you had to leave the workplace. Other policies that a severance agreement generally enforces or reminds you that you are beholden to would be trade secret policies. You can't, once you've been laid off, spill the beans to all of the company's biggest competitors as far as their trade secrets. That would still be something that generally runs afoul of company policies that you've likely signed earlier in your employment, as well as potentially legal violations if you were to use confidential company information to harm your former employer's business interests. There are always variations in these situations, but in general, take the high road and be a good leaver, as they call it, and you'll be in a much more solid position career-wise. Non-compete and non-solicit agreements also will be mentioned in such an agreement, although not always. Sometimes it'll just be part of a general statement that, by the way, anything you ever signed with us during your employment stays in effect after your employment. So one thing you can do when being subject to a layoff or reduction in force is ask the employer, well, can I get a copy of everything that I'm subject to, right? If I signed a lot of stuff when I came on board, may have signed other things just by clicking a box as part of an email or something, and asking for those policies right then and there could be a good way of making sure you're aware of any restrictions the employer has, and that sort of thing, particularly if you are in a position that is client-facing, involves business development or product development, and more of that sort of very sensitive information where you might be subject to a non-compete or non-solicit. And that's a whole other world that if you have questions about that sort of thing, we do quite a bit of work with regard to non-competes and non-solicits. Now, the most common question that people ask, of course, is my severance good? Am I getting, is this an appropriate amount of severance? That sort of thing. Very difficult to answer. It's obviously case by case, but of course, with certain facts, we can give you a pretty good idea as to whether your severance is standard, whether it's a relatively generous severance, although you hate to use that term in connection with anything having to do with the layoff or a RIF. Standard corporate America practice where a company is offering severance is a formula somewhere in the range of a week or 2 weeks per year of service. Sometimes that will go up to a month. But that said, it doesn't mean, great, if I have my 2 weeks per year of service, I'm all set, I'm just going to sign this agreement. If you believe you have any potential legal claims, if you believe that there is any money that you've recently brought into the company or that you were on the cusp of being entitled to, if you think there was anything wrong with your termination in the sense that you may have been terminated for a reason that was unlawful, you made a complaint about something in the workplace and you're being terminated in part for that, you made a request for some sort of accommodation, especially having to do with a medical condition or illness, or the illness or condition of a relative, or that you may have been treated less favorably than other employers because you are a woman, because you are of a certain race, religion, or have a medical condition or suspected, it really is a good idea to have somebody take a look at those documents and have a conversation about that situation. But that said, employers are not legally required, generally speaking, to give you severance unless you have a contract that requires it. Most people are at will, meaning they can be terminated at any time for any reason, so long as it's not an unlawful reason. And by that same token, the employee can leave, is free to leave at any time without notice for any reason. But that said, obviously, the equation typically favors the employer. So as far as severance and other things to look out for, severance can be negotiated for all sorts of reasons, not just because you have potential legal claims, although that's generally the strongest leverage to negotiate additional severance, but also if you do have money that what you were on the cusp of receiving, right? That may have been part of the reason for the layoff, unfortunately, but it could be something to negotiate, saying, look, can I get my prorated bonus? I was on the cusp of having this amount of money vest, right? Or if you have, family situation that really militates for your benefits or employment being extended for a certain amount of time. Sometimes employers will extend your employment without pay to make it easier for you to find a new job, because you can still represent, tell employers, hey, I still have my job, even if you are on a paid leave with the previous employer. Sometimes it's too late for that sort of thing, but those are the sorts of things that you can negotiate. Certainly any of us is happy to talk with any of you about that sort of thing. Other things to look out for in severance situations would be, or a layoff situation, is your benefit status, making sure that you have all the information you need with regard to your retirement savings plan, your 401k, right? Find out, hey, am I still going to get my matching funds? If you're at a company where they match 401k funds, making sure that's still going to come through. Finding out the status of all of your compensation, if you are fortunate enough to be in a situation where you have equity or stock or options or things like that. Are those things, what's going to happen to those things? Getting a schedule of, getting a list of what you have and what you may be losing. And the biggest item, and everyone worries about this, whether you are the CEO or whether you are cleaning up the office at night, which is health insurance. You know, we represent people, some people who make, you know, seven-figure, salaries and bonuses, and even folks like that worry about their health insurance. What am I going to do without coverage? So some things to keep in mind there. And some of this is basic, but it bears mentioning. Not everyone is aware of it, believe it or not, but your health insurance will continue typically through the end of the month in which your employment was terminated. So hypothetically, if somebody's employment ended on April 17th, that health insurance continues in effect on the same basis through the end of April. And May is when your health coverage situation changes. But that said, that's also a common part of a severance packet, which is Cobra Information. People are often not given Cobra Information up front. And let me explain what Cobra is for those who may not know. So Cobra is a federal law. It stands for the Consolidated Omnibus Budget Reconciliation Act. And now you know why we just call it Cobra. It essentially allows people to continue their health coverage on the same plan, but instead of the employer paying for a portion of that coverage or all of it, the employee must pay for that coverage. And obviously that is a substantial monthly expense, but it at least gives people the ability to continue their health coverage when they need it. So how does that work? And what information do you be getting? Well, you typically get a general Cobra notice document explaining how it works, as well as a Cobra election form. So a form that you would have to fill out if you do want to sign up for that Cobra and pay that, that premium, at least for the time being, to bridge your coverage. And Cobra coverage is retroactive, by the way, because employers get a certain amount of time to give you that notice. They don't have to give you that notice at the very beginning, although they should. And if you don't get one, certainly ask for it as soon as possible. But if you get 60 days to sign up for Cobra, and once you do, that coverage is going to be retroactive. So in the meantime, let's say the April 17th scenario, you have a doctor's appointment on May 2nd. You go to that doctor's appointment. It's up to you whether you mention your coverage situation or not, but typically you can provide your insurance card. And if you're planning to sign up for Cobra, by the time that doctor's office gets around to billing your insurance, you'll be all set and it should continue seamlessly. But do ask about that. And something to know about Cobra, you can continue your benefits for up to 18 months, assuming that all the proper conditions continue to apply. In New York, we're lucky enough to have that go to up to 36 months because New York has its own supplemental Cobra statute. There's obviously so much more we could talk about on that topic, but I see that we have a question coming in from Keenan. I own a family business, and they're in the same boat with thousands of other small businesses that didn't receive anything from the stimulus package. And they learned this morning that big companies somehow got an exemption and were able to get more than 50% of the funding. Will there be a potential class action against those companies or against the government in this regard? Difficult to say off the cuff, and definitely, Hillary, Julie, if you have your own take, I want you to jump in. But to me, unless there's something fraudulent about those applications or something else that was unlawful about how that was done, as long as they're operating within the parameters of the law, it's probably more of a political question than a litigation one. But again, we're typically, we do some consumer protection work, but there I wouldn't want to just shoot from the hip and give you a straight yes or no, but likely it's not necessarily a cause for litigation, although definitely a reason to, no joke, call your congressperson and let them know about this situation and your displeasure. Hillary, Julia, did you want to add anything on that?
I would just say we've definitely seen a lot of people contacting their government officials, and a lot of people have taken to social media as an effective way to get their point across. So if you believe that the policy is in some ways unfair, then I would certainly urge you to do that. If there is something that you believe you're eligible for that you're not getting for some reason, it's hard to say without the details right now, but you can definitely reach out to us separately and we can discuss whether your situation is one that calls for litigation.
Yeah, and, we are more oriented and prepared for our area of practice really is more for the employee side rather than the management side or corporate side. But that said, something probably to talk with a corporate attorney about, or your bank would be another place to go. Okay, so any other questions at the moment? There were some questions that we got during the week. I don't know if we want to take those or if we want to continue, Julia, with you talking about the whistleblower laws.
Sure, I can give a little overview on the New York whistleblower laws. And then if, in the last 2 weeks, I've kind of been talking about New York paid sick leave and the type of sick leave that you might be entitled to under the FFCRA, which is the federal law. And so if people have questions about that, I'm happy to go over the different facets of that law as well. Just right into the YouTube live chat. So New York does have its own whistleblower law, which bars employers from retaliating against an employee because the employee has disclosed or is threatening to disclose to their supervisor or to a public body like the government, a violation that creates and presents a substantial and specific danger to the public health or safety. So obviously in times of COVID, a substantial and specific danger could be that your employer is not complying with the COVID guidelines that the government has set forth. And so this might come up. And another part of the New York whistleblower law protects employees from being retaliated against by their employers if the employee threatens to disclose or does disclose to their supervisor that the employee in good faith reasonably believes that whatever the activity is that the employer is doing constitutes improper quality of patient care. So of course, this is also relevant right now as hospitals are overboarded with patients and don't have proper PPE. So these are things that might come up, and it's important to know what your employer is or is not allowed to do. And one thing that's important to note is that if you want to be afforded these protections and you believe that your employer is presenting a substantial and specific danger to the public health or safety of New Yorkers, then you first have to speak to your employer about it and tell them why they are violating this law, and then you have to afford them a reasonable opportunity to correct the unlawful activity before you go and complain to a public body about this. So you must speak to your employer about it before, tell them why their company or employment facility is in violation, and then you have to give them some time to correct their mistake. And so what I wanted to share with you today, and I'll just share my screen here, is the COVID-19 complaint form. And I hope everyone can see here. You just go to forms.newyork.gov, and there's the Department of Labor COVID-19 complaint form. And if you believe that your employer is violating any of the New York on pause orders or the guidelines about what does and does not constitute an essential worker or an essential place of employment, which we went over last week, and I'm happy to discuss if people have questions about that, then you can submit a complaint and just kind of let the government know that your employer is either requiring you to come into work when you're not an essential employee, or not giving you paid sick leave when you believe you're entitled to it, and you can explain why. And it seems pretty self-explanatory here. But if anyone has any questions about it or where to find this form, then we are happy to tell you more. So with that, I'll turn it over. I don't know if we have, if we have any questions, but I can turn it over to Hillary, who will give more unemployment updates.
Yeah, and Hillary, provide the unemployment update, and then there are a few other laws that I would like to just mention as far as laws that you can lodge a complaint under in this kind of environment. But no, but I know that people are very, very eager to hear about the unemployment, so I don't want to get in the way.
Sure, Larry, thanks. So there have been a few updates in unemployment guidance that we have received from the Department of Labor since we last connected, because things are just constantly changing very rapidly. And then I also wanted to provide a little bit more information because we've gotten a lot of questions about when might it be okay to quit your job. So first off, so I just wanted to provide this website that the Department of Labor has recently included, and it provides, let's see, share here. So this provides new updates and information about unemployment insurance relief during COVID. So this is on the federal Department of Labor website, not the New York Department of Labor. I know most of the links that we've been sending are from the New York's website, but this is from the federal Department of Labor website. And they provide some information about how to apply, guidance, fact sheets, news releases, frequently asked questions, and where to file. So this is very helpful and has answered a few questions and filled in a few of the gaps that people have been asking about. So just one that I wanted to point to that we have seen come up again and again is this question here, which let me move this over. So my employer has remained open because it is essential. I'm not sick, nor is anyone in my household sick. I do not have children or care for someone who cannot care for themselves. However, I'm afraid of getting coronavirus from customers coming into the store, so I quit and filed unemployment. Can I obtain benefits under the CARES Act? And this gets into the issue that we see again and again and again, which is I'm concerned for my own safety. I'm not immunocompromised. I don't have any underlying conditions, but I'm still concerned about getting coronavirus. Can I quit my job? And the answer is if you quit your job under those circumstances and you don't have a recommendation from your doctor, then you're not going to be eligible for unemployment benefits under the CARES Act. So this explicitly states that answer because it was a little confusing based on the previous guidance. The text of the law says that if you quit for a reason related to COVID-19, then that would make you eligible for unemployment benefits. But this makes it clear that one cannot just decide that they have to quit because of COVID-19. They need to get guidance from a medical professional saying that because of your condition or because of the condition of someone in your household, you should make sure not to expose yourself to the virus. You're particularly susceptible to the virus, or you could have particularly harsh or severe symptoms. So this guidance is very helpful. I hope that it answers a lot of people's uncertainties when they're struggling whether or not to quit their job. Just keep in mind, again, this is a right to work state. Unless you have a contract, you likely can quit your job. It's just a question of whether or not you'll be eligible for any sort of unemployment benefits or any compensation after you quit. And chances are is that you won't be eligible for any compensation from the Department of Labor if you quit your job without some sort of medical guidance.
So Hillary, you mentioned medical guidance right there. What sorts of factors might allow someone to leave a situation and still be eligible for unemployment or quit under other laws that might provide them some kind of protection?
Sure. So there are a number of different circumstances when someone can quit their job, with specifically related to the CARES Act. So what the CARES Act does, just as a refresher, or for people who are viewing for the first time, is there are traditional unemployment benefits, and then the CARES Act created a new pandemic unemployment benefit, which people can now potentially be eligible over and on top of the traditional unemployment benefits. So when I'm talking about the CARES Act or pandemic unemployment assistance, pandemic unemployment benefits, that's over and above what people could have been traditionally eligible for. And a lot of these standards would still qualify for someone under the traditional unemployment benefits. So what I can do is I can show it's right here. So this is the Claimant's Handbook in the New York Department of Labor. And so in the Claimant's Handbook, it explains when people are eligible for unemployment benefits and when they're not eligible for traditional unemployment benefits. And essentially, if you look here, it says there are two reasons why you wouldn't be eligible, so would not be eligible. And that's if you quit your job without good cause, or two, you were discharged, fired for misconduct. So focusing on the first part, you quit your job without good cause. Well, what is good cause? Under the unemployment insurance laws, which are different than traditional employment laws. So let's keep that in mind. Under the unemployment insurance, it's a little bit more broad, a little bit more forgiving than the traditional employment laws. So under the unemployment insurance, someone can leave their job for good cause and not be disqualified for benefits. And that good cause can mean a number of different things. So some examples that the Department of Labor provides as good cause are if you're in a domestic violence situation where your safety or the safety of your immediate family would be at risk if you stayed in your position. If a member of your immediate family has an illness or disability that requires you to take care of them for longer than your employer is willing to grant time off for. So this is something that's coming up with coronavirus, but it was actually built into the traditional unemployment benefits. Some other examples are if your spouse's employment location changes and you need to change locations with them, and you can no longer easily commute to your job. So let's say your spouse gets a new job in California and you're not able to telecommute to your position in New York. You have to physically show up. That could be a good cause reason to quit your job and still be eligible for unemployment benefits. And a few other examples include if the Department of Labor determines that your pay and or hours of work were reduced substantially. So this is a little tricky because and this is happening all the time right now, where people are getting pay cuts. Traditionally, if you receive a pay cut of 10% or more, then that could be good cause to quit your job. That said, if you receive a pay cut of about 10% and then you decide to live with that 10% or 15%, even 50% pay cut, you decide to live with that for a few months, then the Department of Labor may say, listen, you were fine with having a 50% pay cut for 2 months. There's no reason why now, 2 months later, you feel like you have good cause to quit your job. So you want to be careful if that's the reason why you're quitting your job and why you believe that that's good cause for quitting your job. You want to know how recently the pay cut was and how drastic the pay cut was. Another question that I've received quite a bit is whether or not if you have good cause to quit, if you would be receiving more pay under unemployment benefits than you would in your job. So let's say you have a minimum wage job, you do the math and you'd be getting more money if you quit your job and signed up for unemployment benefits. That in and of itself is not a good cause, just because you could be getting more money under the unemployment insurance provisions. However, if there was another reason why you quit your job, then you apply and could get more money under the unemployment insurance provisions, that might make you eligible. And it's also very important to include the reason why you're quitting your job when you're certifying for benefits. You want to make sure you're being absolutely truthful, because if you do lie to the Department of Labor, then that could be considered a fraudulent misrepresentation and you could be fined for that. So it's extremely important that when you're certifying for benefits, you are being absolutely truthful in that certification process. And then one last bit that I wanted to address, which coincides with what Julia was talking about. If the Department of Labor determines that your former employer did not address a safety hazard. So if you complain to your employer that you're not getting the proper equipment that you need to safely do your job, right? If your employer is not giving you masks, even though you're coming in contact with customers, something like that, and you're not getting the protections that you need, and you legitimately need these protections, your employer does nothing about it after you complain, then that could be good cause. And again, I say could be because if you look here, it says the Department of Labor determined this, not that you determined this. So you want to make sure that the standard is that the Department of Labor would agree with you, not just that you have unilaterally made a decision. We've gotten a few questions, so I want to turn it over, I think first to Julia about answering that question. And I also just want to remind everyone that they can submit their questions on the live stream on YouTube or on Facebook, as well as by email on the contact Wigdor email that's on the flyer. Thanks.
Great, thanks, Hillary. Yep, we got a question here, and the question is, can I take paid sick leave if I have a doctor's note stating that I probably have COVID-19? And so, yeah, the answer to that is that you have to provide documentation to your employer if you want to take the specific New York COVID-19 paid leave. And I'll just share my screen here actually so that people can see the documentation guidance. And so the documentation guidance for New York is that you have to have your licensed medical provider say that you probably have, that you're symptomatic and that you probably have COVID-19. And they have to attest to that. And then you do have to get in touch with your local health department to try to get an order for a mandatory quarantine from your local health department. But in the meantime, since those health departments are probably overwhelmed with calls and understaffed, you can just use your doctor's attestation saying that you probably have COVID-19. And then you do have to fill out 2 other forms, which are available on the New York Paid Family Leave website. And then with those 2 forms, you have to submit them to your employer, who is to return them in 3 days to you. And then you submit them to your employer's insurance carrier. So a lot of employers do need to provide this type of leave, and how many days you get depends on the size and the net income of your employer. And if people have further questions, they can look on our website at our blog, because there is a whole blog post about who qualifies and how many days you get. So with that, I think there's another question, and I'll turn it over to Larry.
Thank you, Julia. Yeah, so we have a question here. Someone who works for a company, a large company, several thousand employees in New York State. And she is hearing that there may be a mass layoff affecting a few hundred employees. And she's wondering whether or not she's entitled to some kind of notice up to 90 days, which is what she's heard from some coworkers saying that that's required under the law, that they need to keep receiving their regular paycheck for that long. This is one of those caveats, the idea that severance is not legally required. Under very, very specific circumstances, there are 2 laws that would be relevant here in New York that could kick in here. The first is the Worker Adjustment and Retraining Notification Statute, which is a federal law, and then New York has its own, and that's called WARN. Everything has a cute acronym. And then there's a New York mini WARN statute that supplements that. So understand that these are statutes that are meant to soften the blow of plant closings, where an employer knows in advance that a large portion of the workforce is going to be laid off, right? And they're very specific levels that apply to all these things, numbers, as far as the number of employees the employer has to have. So typically under federal law, it's 100 employees or more the company needs to have. New York law, it's 50 employees or more. Federal law, you're typically looking at a layoff that affects 1/3 of the company's workforce, at least 50 employees, and requires 60 days notice, actually. But under New York, the thresholds are lower for the notice to kick in, and that's 90 days under New York law. If the employer lays off 1/3 of its workforce, at least 25 employees. Federal law, they need to be laying off at least 50 employees, like I said. But that said, there are important caveats there. And because at first blush, it sounds like a really great law. Hey, if a plant is closing, if an employer is just closing up shop or shutting down a single work site where that many employees are affected, you have to give notice, right? Or the monetary equivalent thereof. You know, you can pay in lieu of notice. But there are exceptions to this. For instance, there is what's called a faltering company exception, meaning the company is still trying to stay open. They're seeking a loan, they're seeking other investment to keep the doors open. And if they let it be known, if they gave the WARN notice, that would hurt the chances of getting that funding, which you can imagine is often the case. There's also, there are other exceptions as well for not being able to reasonably foresee the business circumstances, which is kind of an exception that might swallow the statute to an extent, because how many times are people going to say they could reasonably foresee going out of business? And certainly that would apply in many cases you could imagine here, where the pandemic struck, and life changed seemingly overnight, certainly over the course of a week. And the third exception is a natural disaster. Unclear whether a pandemic would be considered a natural disaster, like a Hurricane Sandy or something like that, or Superstorm Sandy, but you can be sure that lawyers everywhere are going to be fighting over issues just like that across our country. So the short answer would be, it really depends on how foreseeable this layoff is, right? Whether the employer is going to be phasing out workers in an orderly fashion, but staying in business. And if so, the employer may be required to give you some kind of notice. But again, the details as always matter. But it's an important law to know about, the federal WARN and New York State mini WARN statute. So let's see. Let's see, are there any other questions that we want to cover here?
Yeah, I think we got a question. My child's school has been closed and I need to take care of my child. How much sick leave do I get and how much do I get paid? So under the New York COVID paid sick leave law, this is not a reason that you can get the 2 weeks or however many days it may be to get the paid sick leave. But under the FFCRA, if your child's school is closed or place of care, like their daycare, for reasons related to COVID-19, you do get some leave. So the guidelines state that a full-time employee is eligible for up to 12 weeks of leave at 40 hours a week. And then the way that you get paid depends on how much you make. So employees who take leave will be paid at 2/3 of their regular rate or 2/3 the applicable minimum wage, whichever is higher. So of course, if you make more than the minimum wage, then you are going to be getting paid a lot less money than you typically would for this type of leave, because it's going to be based on 2/3 of the applicable minimum wage. So it does depend. If you make the minimum wage or something lower, then you might be getting a little bit less than that. And then you, over a 12-week period, you could format this as 2 weeks of paid sick leave, followed by up to 10 weeks of paid expanded family and medical leave, which are all federal statutes. In New York, since I think a lot of schools are closed, and certainly all in New York City, you cannot take the COVID-19 paid sick leave for this. So you do have to look, unfortunately, to the federal laws.
And also, just to piggyback off of what Julia was saying, if you do need to care for your child because your child's school is closed, or your child needs to stay home from school, then and you need to you need to quit your job as a result, then you could be eligible for unemployment benefits. So even if you have the option of telecommuting, but you can't telecommute because you have to watch your child throughout the day, and I'll share my screen here to show you exactly the guidance of the New York State Department of Labor. But if you are the primary caregiver, right? So this does not include secondary caregivers, or if the child has some other person taking care of them. If you're the primary caregiver for a child unable to attend school or another facility closed due to COVID, then you would be eligible for the new pandemic unemployment assistance. And just as a reminder, the way that if you're only eligible for pandemic unemployment assistance and you're not eligible for traditional unemployment benefits, then you do still need to apply for traditional unemployment benefits. And I'll show you this chart again. So what you need to do, even if you're not traditionally eligible for UI benefits, which based on the law, someone who needs to care for their child and isn't capable of working at the same time, they traditionally would not be eligible for unemployment benefits, but they would be eligible for the new pandemic unemployment assistance. Then you would fall under this category, and you still need to apply for unemployment benefits. You will receive notification that you're not eligible, and then at that point you'll be able to apply for pandemic unemployment assistance. So it's not the most streamlined process, but it is the process that's currently in place in the Department of Labor. And then just so you know, if you haven't been on the Department of Labor's website recently, you'll see that there are all of these notifications, and that's because the New York Unemployment Insurance Board has created a new way to file online. And so when you file online, it's not the traditional process that it was. There's a new online portal that you can use that you log into, and that's for people who are applying for unemployment benefits for the first time. So if you applied for unemployment benefits, you're still waiting to hear back, don't submit a new application through this online portal. It's just going to slow things down. But if you haven't applied yet, you want to make sure to apply on the new online portal and not the traditional method of certification, which is a separate online application, or by doing it over the phone. Your application will get processed much faster through this new online portal from what we've been hearing.
Great. So basically, one thing I did want to come back to about the question of severance, it's a wrinkle that a lot of people aren't aware of. Most people think of severance as always being paid out in a lump sum. You just get it all at once, but very often severance agreements will provide for severance to be paid out on a payroll basis. You'll get it over the course of however many weeks or months that you're going to get. And that will often come with its own set of conditions. For instance, it may cut off if you get a new job. It also could even require you to pay back some of the severance if you get rehired by the company at some point, and it's at a point less than the amount of severance that you got. So those are things to watch out for also in severance agreements, reading them very carefully. And that can also be negotiated as far as the amount of time something will be paid out over, or the strings that are attached to that. Let's see. I was going to talk about some other laws that protect people who make workplace complaints, but are there questions that we want to cover before I do that?
Sure. So there's one question that I can answer that we received over the week, which is, can I take long breaks during the day, such as a nap for 2 to 3 hours, but still work for all 8 hours because I'm trying to work even though I have the virus and still get paid? So according to the Department of Labor's guidance, that yes, if you are working remotely and you're able to do so, then you should be able to continue to take breaks during the day. You just want to talk to your employer and make sure that that's actually a plausible accommodation. So for instance, if you have the type of job where you need to be on call for those 8 hours, then that might not be an accommodation that your employer can make. However, if let's say your employer can rearrange your schedule reasonably to accommodate you needing to take 2 to 3 hour breaks for naps during the day, then that is something that your employer should be doing. They should be giving you a reasonable accommodation when they can, and then you should be able to continue working. However, if you're an essential worker, if you're the type of person who needs to physically be present to perform your work, then according to the Department of Labor's guidance, then your employer, again, unless it's a reasonable accommodation that they can easily accommodate, then you might not be able to go home for 2 to 3 hour naps. And again, this has to it comes back to communicating with your employer, seeing what your employer is able to do. If it's something that they can do with your schedule, then they should be doing it. And if you have specific questions as to whether or not a request for an accommodation is reasonable, you should definitely reach out to us and talk to us, because we can provide further guidance and information about what your employer is obligated to do.
Yeah, and if that person is sick, you may be entitled to the paid sick leave, right? So just keep that in mind. That's or just frankly leave in general from your job with an entitlement to return to your position when you're well. And in the event that you do need to take time off because you are ill with COVID or frankly anything else, and you're terminated for that reason, that raises questions under federal, state, and local law all on its own.
And we received a question that we may just need some follow-up information to really answer, which was, what about city employees facing hiring freezes and budget cuts? So I think we need a little bit more information about exactly how we can advise you to help you if the issue is that there's not enough staff because of hiring freezes or budget cuts for you to do your job safely, or if you're unable to get a new job because of hiring freezes or budget cuts. So you can either follow up in the live stream or reach out to us separately, just to provide a little bit more information about the situation so that we can provide our guidance.
Yeah, and I'll just say city employees are entitled to 2 weeks, 14 days of paid sick leave if they have the proper documentation. So I'm not sure exactly what the concern is, whether people need to take time off because they have COVID and they have a mandatory or precautionary order of quarantine, but city employees do get 14 days.
Okay, I see we have a couple of other questions. One of them I'll take with regard to an employee who is older and sees the younger employees typically getting all of the remaining office hours, that sort of thing. But first, there's also a question just generally about how people can file safety complaints. And I know that we've had this in past weeks. Hillary or Julie, did you want to just give people some quick pointers on where to take those sorts of complaints? And I know that people can file anonymous complaints as well.
Sure, yeah. So there's the website that I referred to earlier, which is the New York State Department of Labor website. And I'll just share my screen again here so that people can get the exact website address. But it's I'm sure if you type into Google New York Department of Labor COVID-19 complaint form, you can complete this form and describe why you believe that your employer is engaging in illegal conduct that relates to COVID-19. And you can also read more about this at labor.newyork.gov about what types of complaints are there. And while that is loading, We also went over last week the guidance for determining whether your business, your employer is an essential business, which of course has to remain open, like hospitals, walk-in healthcare clinics, nursing homes, and then grocery stores, that type of thing. So if you fall into these categories and your employer is remaining open, they likely are allowed to be and should be. But if they're not providing masks and you believe that they should be, then that is an exact type of complaint that you could make to the Department of Labor. So I know there's another website that we shared last week, maybe Hillary has it, to make complaints. I think it was probably the Federal Department of Labor.
Yeah, so I think the one that I shared last time was actually through New York City. So if you some easy ways to do this, there are a number of different avenues that you can make these types of complaints. There's one, if you Google complain New York City essential worker, it will pop up. You can also call 311 if you're concerned and you want to make a complaint about your employer not respecting the pause on New York laws, or if they're misclassifying you as an essential worker when you believe you're not an essential worker. So that's another way to issue complaints. You can also file a complaint on OSHA's website, and I can show that quickly here. So if you go on OSHA's website under the Workers' Rights tab, that'll be on your left when you initially enter. There are two options to file a complaint through OSHA, which one is file a safety and health complaint, and then the other is a whistleblower complaint. So if you're complaining to your employer and your employer is retaliating against you, if you've been fired for making a complaint, first of all, you should definitely contact an attorney to find out more about your legal rights. But OSHA also has a place on its website for you to file a complaint. But again, if you have been retaliated against for making a complaint for any of these reasons, then I would definitely consult with an attorney. Make sure that you know your rights before, if you would like to make a complaint, because you want to make sure that you're making a proper complaint and a protected complaint. So I would highly recommend that.
Great. So please, by all means, get them in. We'll try to do a lightning round, or certainly you can email us, go to our firm's website, and all of our contact information is there, and happy to talk with any of you, over the course of the next week. And but if anyone else has any questions, please shoot them over to us. I guess just wrapping up, one question or point that I really do want to make is, we think of whistleblower laws in a very specific way. Going to make a complaint about a company doing something illegal in a public safety sense or financial sense, and that's definitely true. But those laws tend to be very narrow in application. Whistleblower laws, to my mind, actually can be much more broad. There was a question that I alluded to, someone saying that the younger employees seem to be getting favored for getting office hours and new work, and whether that's legal. It would not be legal if your age is the factor in play, right? If you are being disfavored because you are an older employee and the employer is favoring the younger people for that reason, and there could be various indicators as to why that might be, or whether that's the case. But that would be unlawful under the New York City and New York State human rights laws. It would also be if you were to complain about that situation, for instance, and say, I believe that I'm being discriminated against, or I believe this is wrong, that the younger employees are being favored, and you suffered consequences for that. You were fired, you had even less work given to you, whatever it is, that would be unlawful retaliation. So to my mind, that applies to all of these discrimination, being discriminated because you need for an accommodation, being discriminated against because you did point out an unsafe practice, or something that an employer was doing that was fraudulent, right, in connection with an application for aid, for instance, from the federal government. Those are all complaints that could potentially be legally protected. And if you suffer consequences in your job because of those complaints, there's all grounds for retaliation claims. One law that I'm going to point out that pertains to our area, our geographic area, is the New Jersey Conscientious Employee Protection Act, which is a great law. It's much more comprehensive than the whistleblower laws that we actually have here in New York. Not sure how that happened, but there you have it. And it's a great law that applies to people working in New Jersey who make a complaint about anything their employer is doing that may be that is unlawful or fraudulent, or misrepresents something to a third party, business partner or former employee or the government. And there are laws like that as well that protect the federal government. If somebody makes a false claim for money to the federal government, this comes up often in the medical and hospital area where people are making a habit of filing trumped up claims for Medicare reimbursement and things like that. So know that all sorts of complaints that you make, objections, may be protected. And if you, again, feel you're being retaliated against, you should speak with an attorney about it. Okay, so anything else? We wrap up? All set? All right, well, everybody, thank you so much for attending. We're going to leave it there. And again, any questions you have, reach out to us. We're happy to talk with you. Thanks so much.
Thank you.